The next matter to come before the court is in re TP. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, please let me know, as I'm keeping the clock this morning and will keep you apprised of the passage of time. We've read the briefs and we are ready to proceed when you are.
Happy Easter, Your Honors. My name is Ken Martin. I represent the appellant in this case, Mr. Dante Palm. He is the father of Alina Palm. And the court's had an opportunity to review my brief and the law, so I just want to talk a little bit about Mr. Palm and point out to the court that he's a suitable, loving, caring parent to his daughter. And at the trial, the court stated there would be a determinant of suitability at the end of the proceedings. However, the magistrate's decision fails to make a separate finding, and evidence presented at the trial failed to meet the burden of proof to show that he is not a suitable parent. Instead, the lower court, in our opinion, abused its discretion, and in relying on the best interest of the child test and awarding custody to a non-parent rather than the biological parent. The award of custody, wholly absent of a separate finding upon suitability, we believe violates Mr. Palm's fundamental constitutional right to raise his child. Mr. Palm had supported the child financially. He had provided housing, clothing, food, and other necessities for the first 9 months before he separated from Talina's mother. And there were never any allegations that he was unsuited to care for her. Even after the separation, Talina's mother continued to allow Mr. Palm to care for and watch over their daughter. At trial, it was undisputed that Mr. Palm actually provided adequate care for his daughter. Mr. Palm, in fact, comes from a large family. He has 24 nieces, nephews, and he has at different times cared for them. In addition to caring for his daughter, Mr. Palm, I want to point out, is on disability. He receives, I believe it is $1,100 approximately per month, and he pays child support right now of $50 per month. Further, Donna's mother, Linda Palm, intends to be with the father and daughter's life and assist as needed. In fact, Mr. Palm lives with his mother. And all this supports the conclusion that Mr. Palm is suitable to raise and parent his daughter, and even the lower court did not rule that to the contrary. Now, Mr. Palm and his daughter have a loving relationship, and I believe it's important for a parent to raise his daughter. He does have a paramount right. He demonstrated to the lower court that he is able to meet his monthly financial obligations and be able to take care of the child adequately. And his housing situation is also adequate to meet the needs of the daughter. He's in good mental health, he's in good physical health. Yes,
as to the housing arrangements, I understand that he and his child would reside in the same bedroom?
I'm not certain of that, Your Honor. I can't answer that. But he's in, as I pointed out, he's in good physical and mental health, and he should be granted the opportunity to raise his daughter. I do want to mention about the issue concerning the GAL. At one point during this matter, and I did not, I'm only working on the appeal, I never appeared in the juvenile court on this matter, but Mr. Palm did ask the court to relieve the GAL of her duties due to what he felt was a conflict in her objectivity. He did not believe that she was effectively representing the child and that she was not objective in her evaluation of the case.
Any specifics on that allegation?
The specifics were, Your Honor, that Mr. Palm brought an instance to the court's attention where the child had actually been harmed by an object that was hot. I believe it was a curling iron, and that she had been burned. And the GAL just took no stock of that or no account of it. From Mr. Palm's point of view,
What does that mean? Did someone bring it to the GAL's attention and she say, well, it's of no account? What's the context of that?
She did nothing. She treated Mr. Palm as if he had no credibility and no standing as a father. That's how he felt, Your Honor.
All right.
It seems as if from reading the briefs and the magistrates and the trial court's orders that your client made a very poor impression, not only on the GAL, but on the magistrate in terms of just his affect and his behavior in court. And that is something that this court can only review by way of what's written on the pages of the transcript. But it seems to me that the magistrate took some care to specify the kind of sullen, disrespectful, slouching behavior, and to point out some of the comments that were made in answer to the counsel's questions. That, together with the testimony of violence, incidents of violence, I think made an impression both on the magistrate and the trial court. Would you like to address that?
Well, first of all, Your Honor, I'm going to point out to the law which states that just because a parent is not a model parent doesn't mean that he doesn't deserve custody of his child. Secondly, and I'm finding this a lot in my practice when I'm working with persons like Mr. Palm, but for some reason, and perhaps it's due to the culture, it's due to the parents, it's due to the general situation, the upbringing that the parent has been involved in, they don't have the best manners. I'm not saying to this court that my client has the best manners. I don't believe he does have the best manners. And if you saw him on the street, you may think that it would be not a good idea for you to stay on the same side of the street. But the fact is that my client, he loves his daughter. He did the very best he could to support her. But he's not a model parent. He doesn't have the best manners. And in a lot of these situations, yes, you do find argument. You do find a little bit of violence. And a lot of that, in my opinion, really results from the stress that everybody's placed under from the presence of a child, and because there's not enough income to go around, they have to live with other people. And I'm seeing more and more of that today. I believe my client, and I'm not going to describe him as a victim, but my client is a part of that. He is a part of that situation where perhaps because he doesn't have the resources and perhaps due to the fact that he didn't have maybe the benefit of maybe a more mannerly culture, so to speak. Sure, he was a little rough in court. He was rough in court. And a lot of that was his resentment toward the questions that he was being asked, because he felt that he was being opportuned to the extent that he was being made out to be a bad person. And they were focusing on all of his negative issues rather than some of the positive things are done. But I'm not going to say that you aren't right.
Well,
his effect was poor.
I appreciate your candor on that subject. Another thing that I think made an impression on the trial court was it was obvious that your client did not see eye to eye with the maternal family, but that he was arguing on the one hand that he did not have that he was limited in his visitation, and yet, I hope this is the right case, and yet when he had the opportunity to visit, he did not seize upon that for months on end. And I'm on the same page with you on this case?
You are perfectly correct, and this is the case.
Okay.
And I think my client was a bit intimidated by the maternal grandmother. I think my client felt that he was not respected by the maternal grandmother. And I think because of that, he decided to avoid the avenue that was going to cause him less problems, meaning that, hey, if I go over and talk to the maternal grandmother, if I visit my grandmother, maybe they're going to say something that'll maybe make me unhappy or set me off a little bit, and perhaps it's better if I just take a hiatus from that visit. But you are perfectly correct. In those sorts of cases, when those sorts of situations occur, again, if you have the resources, you can get involved with some sort of organization, a counseling organization that is going to provide a counselor as a mediator or someone who's able to step in and teach people and instruct people how to resolve their differences and how to deal with their anger issues. In this case, that didn't happen, Your Honor, and yes, you are correct. He did take a hiatus from visitation.
Counsel, you have 4 minutes remaining. You may proceed or reserve as you wish.
I just want to point out to the court that I don't feel it's correct for the juvenile court to go in the best interest and then use the best interest factors to determine who has custody. The Ohio Supreme Court has always said you determine suitability first, then you get into best interest. Because the way this took place is, it almost appears that, you know, we always want to give the children to, so to speak, the Rockefellers. Because they've got the biggest home, they've got the biggest refrigerator, and they've got the best toys for the kids to play with. And in making that type of determination and melding the best interest factors to say, well, this person, this grandmother is going to be a better parent, the child's going to have an apparent better opportunity to be with the maternal grandmother, and to deny the father his child, I just don't think that's the correct way to go, especially in a case like this. I think that what the juvenile court needs to take a look at is following the law and not bending the law to give custody to the person who they believe somehow is going to be the better parent for the child. I would like to reserve just a few minutes, Your Honor. Thank you.
Counsel, you may remain at the table.
Oh, okay.
May it please the court, counsel. I just want to address a couple of the issues that came up during the court's questioning regarding some of the facts. I can't remember which of you asked about the living arrangements at Mr. Palm's home, but if you look at the trial court's finding number 11, that Mr. Palm's home lacked adequate living space for the child, and the testimony at trial was that at least when the mother, the father, and the child were living there, they were all living in one bedroom. They had a microwave in there. That was the play area for the child. That's where they ate meals. And the court did address that. And then if you look at, what I did was, my understanding of what the appellant was objecting to was that the court did not make a determination of unsuitability. I thought that was the basis. I did a sufficiency argument in my brief because I thought the court should see some of the facts that the trial court relied on, but I think that's what the assignments of error addressed. In fact, however, though, both the magistrate's decision and the judge's final determination both did address that. The magistrate said that it would be a detriment for the child to be placed in either parent's care. Detriment is one of the actually detriment under the Perales decision. That is one of the factors that determines unsuitability. And then the magistrate listed 6 areas of concern on what she based the unsuitability determination. And then the court did the same thing and then expanded that by stating that it's detrimental to the child and therefore determines the father to be unsuitable. And the court used those exact words. And then goes on to list 11 areas that were of concern. I think that I heard counsel admit that there was a little bit of violence in this home. There was a lot of violence in this home. There was an incident where Mr. Palm lured the mother to a motel with the pretense of giving her money for the child and then assaulted her. It was more than bad manners. It was a total lack of respect for any type of authority, including the court. It was a total lack of respect for people and people in authority that any parent is going to come into contact with. Police officers, teachers. Mr. Palm did not want to get a birth certificate for his child because he didn't want to have to contact the health department for it. He wanted somebody else to do that for him. So it really wasn't bad manners. I think what the court was concerned about was that as he would go through life caring for his child, he would come into contact with authority figures and maybe even people who would not be totally respectful of him or showed him the respect that he thought he deserved, and then there would be confrontations like there were with the police department. The one incident that I think was really telling was in February of 2012, February 12th. Ms. Foster, the biological mother, testified about an argument they had gotten into, that Mr. Palm yelled at her and told her to get the baby to shut up because the baby was crying. She said, "I'm sleeping, you take care of the baby." They got into it. She ended up locking herself into a bedroom. The police were called. Police officers testified about Mr. Palm's behavior when they arrived on the scene and how he was belligerent. I think they might have had to use some kind of physicalness in getting him to calm down. This was in the presence of the child. In fact, there was evidence that there were multiple occasions where there was violence either between the biological parents while they were living by themselves or in the home, Mr. Palm's home, either with her or with other members of his family in the presence of the child. Regarding the one question regarding the guardian ad litem and the injury, it was, I think the child touched a curling iron. The guardian ad litem investigated it, talked to my client, discovered that the child had received care, and Mr. Palm was told what had happened. His big complaint at the time was that no one had really contacted him as soon as it had happened and filled him in. But there was really no concern, and I don't think it was anything that the guardian ad litem didn't pay attention to because she was prejudiced against Mr. Palm. It turned out it was really not that much of an issue. Regarding his visits, not only did he not try to have visitation with the child for like a 5 or 6 month period, the guardian ad litem actually talked to the maternal great-grandmother, and it was the grandfather, I guess, and the step-grandfather that was transporting the child to the visits. They had arranged between them to offer Mr. Palm additional time in the community area of the maternal great-grandmother's apartment building. And Mr. Palm refused, said he didn't want those type of visits. And when I asked him why he had turned down visits with his child, he replied, because at that time I just didn't really want to deal with them like that. I don't remember which judge brought up about his relationship with the maternal family, but it was very hostile. During the proceeding, he called them crazy in open court, basically to my client's face. He was hostile when he talked to the guardian ad litem about the family. He refused to go into any type of treatment. The guardian ad litem recommended a parenting program. He refused to do that. Somebody suggested that maybe he could go into an anger management program, that would show the court that he was taking care of that problem. He refused to do that. At the trial, his position was, I don't want to do anything, I don't have to do anything because I'm going to be getting custody of my child. I think what's important in this case is the standard of review, which is abuse of discretion, but more importantly than this, the law is that the trial court is in the best position to view the testimony, the demeanor of the parties, the testimony of the witnesses. And in this case, I think it's telling that the magistrate specifically said the court could just not find father's testimony credible, believable, or reliable. And in that case, I think the decision of the trial court should be affirmed. Thank you.
Counsel, you have 2.5 minutes, please.
I didn't realize that it was such a blot on your character if you said your relatives were crazy. I guess. I just want to point out. What's that?
Careful what you say.
Exactly. I just want to point out, as far as the JAL is concerned, she submitted an 11-page report. 8 of them, 8 pages were devoted to denouncing my client, Mr. Palm. And I'll also point out, too, that in these cases, there's always a tendency to hyperbolize what's taking place between the parties. An agreement about a child becomes an argument. It becomes an argument. And there's a threat of violence. And somebody raised their voice. As the father of 2 children, I've been guilty of that. Especially when my son was an infant. What I want to point out here is that, taking a look at Mr. Palm's visitation, he's the father. He's been told that his visitation needs to be supervised by the maternal grandmother. And the court really didn't point out why. They just said, this is going to be your visitation. I think we've heard a lot of hyperbole from the appellee. I want this court to keep in mind that there is a standard here. There's been nothing that's really demonstrated that Mr. Palm, in my opinion, is an unsuitable parent. The court immediately went to best interest. They said the maternal grandmother is the best parent for this child. Forget about the father, and here, you can have her. I have nothing further, Your Honor. Thank you very much.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be sent to both sides as well as posted on our website and the Ohio Supreme Court website.
Thank you.
Thank you very much, Your Honor.